Ready, start. We have heard the learned counsel for the parties as also both the parties in person and perused the material on record. Full stop. Firstly, with regard to the divorce decree, as noted above, the respondent has submitted that he has already remarried in the year 2019 and the mediation proceedings as well as the submissions before us were only aimed at reaching a consensus on one-time settlement amount. Full stop. Even in the signing of paragraph of the impugned order, the High Court had also observed that even on the said day, the wife was ready for a divorce, but she was claiming a huge amount. Full stop. Hence, it is evident that the subsisting dispute between the parties remains only concerning the maintenance amount, and both the parties have agreed to the grant of divorce, therefore, we do not find it fitting to unnecessarily delve into the veracity of allegations of cruelty leveled by the respondent against the appellant. Full stop. Considering the fact that the husband has already remarried, the present parties stayed together for only about 2 months after the marriage, have no intention to continue their marital relationship, the marriage between the appellant wife and the respondent husband has evidently broken down irretrievably. As such, we are not inclined to interfere with the decree of divorce granted by the family court and confirmed by the High Court. Full stop. Now moving ahead to the contention with regard to the maintenance amount in favor of the appellant wife, both the parties have agreed that a one-time settlement amount may be awarded to the appellant but failed to reach a consensus on the said amount due to a non-agreement on the financial position of the respondent. Full stop. On the question of permanent alimony and relevant factors for consideration, this court has laid out the factors in detail in Rajneesh versus Neha, which have been reiterated time and again in various judgments and were also detailed in the recent case of Kiran Jyot Mani versus Anis Pramod Patel. Full stop. The status of the parties is a significant factor, encompassing their social standing, lifestyle, and financial background. Full stop. The reasonable needs of the wife and dependent children must be assessed. Full stop. The applicant's educational and professional qualifications, as well as their employment history, play a crucial role in evaluating their potential for self-sufficiency. Full stop. If the applicant has any independent source of income or owns property, this will also be taken into account to determine if it is sufficient to maintain the same standard of living experienced during the marriage. Full stop. Additionally, the court considers whether the applicant had to sacrifice employment opportunities for family responsibilities, such as child rearing or caring for elderly family members, which may have impacted their career prospects. Full stop. Furthermore, the financial capacity of the husband is a critical factor in determining permanent alimony. Full stop. The court shall examine the husband's actual income, reasonable expenses for his own maintenance, and any dependents he is legally obligated to support. Full stop. His liabilities and financial commitments are also to be considered to ensure a balanced and fair maintenance award. Full stop. The court must consider the husband's standard of living and the impact of inflation and high living costs. Full stop. Even if the husband claims to have no source of income, his ability to earn, given his education and qualifications, is to be taken into account. Full stop. The courts shall ensure that the relief granted is fair, reasonable, and consistent with the standard of living to which the aggrieved party was accustomed. Full stop. The court's approach should be to balance all relevant factors to avoid maintenance amounts that are either excessively high or unduly low, ensuring that the dependent spouse can live with reasonable comfort post separation, full stop.